minute you put your work into a fixed form, or we talked about it had to be fixed in a tangible medium, at that moment of fixation, your copyright attaches.
It does, okay.
So if what we're talking about is copyrightable material, it's sufficiently original, and it's your expression, which your photograph is, then you have a copyright.
Okay.
The question is, and you don't have to put the notice on, you don't have to register, you don't have to do any of those things, but you should do all of those things. Right. It is a derivative work.
No matter what I do to it.
Yeah, but the question is, and what we didn't get into in the session, was that for all of the bundle and all of the rights that exist, there are a lot of exceptions in the law, and fair use is one of them. And it really depends a lot on what you're doing with that work. You mentioned collage, and if you're taking, I don't want to say small because it's not just about quantity. Fair use is a difficult concept to get your arms around, and there are 4 factors we have to consider in fair use. The amount is just one of those factors, and here's an example. Gerald Ford wrote his memoirs, and a magazine scooped his book the day before it was to be published, and they only took like 300 words of the whole enormous book, which is a very tiny amount. But that was too much because it was the quality, not the quantity, because the words that they chose were the heart and soul of that book. And they were using it for the same purpose as the book, to convey that idea. And so that tiny bit was too much. On the other hand, you could take an entire portrait or an entire work of art, and if you're sufficiently transforming it, not just that you're making changes, but that you're creating something that has a different purpose from the you're not just replacing the original, you're creating something with a totally different purpose, then that can be okay. And what I'm saying to you now is not going to send you home with an answer, because the answer is you have to do a fair use analysis, and there's no simple, quick way to do that. But that's what you have to do to answer your question. The interesting question comes up is if you're taking somebody else's work and doing something else with it. And and certainly if you're creating a new work and it's obviously derivative, it is. The interesting question has come up where companies, like novelty companies, have legally purchased individual copies of works of art and physically affixed them on tiles and sold those tiles. And in court decisions, it's gone both ways. Some courts have found that that's a derivative work. Because it's serving a different purpose than what the artist intended. They bought it legally. They didn't reproduce it. They didn't violate any of your rights. Well, they may have violated number 2 as a derivative work, but they didn't reproduce it they legally purchased that copy and put that copy on a tile and sold it. Some courts said that's not okay. Other courts have said that is okay because it's just how you're choosing to display it. It's like if you put it, the tile was like a frame, and you legally owned it. And there is a concept in copyright law called the first sale doctrine, where if you buy a piece of artwork, you own the physical thing. And you can do pretty much whatever you want with that thing. You can't exercise any of the rights from the bundle of rights, but for the physical thing itself, you can sell it, or you can give it away, or you can rent it, or you can destroy it. And so these other courts that said that was okay, we're saying basically, they bought the thing, they owned the thing, they could do whatever they want with the thing. Who owns the work in those museums? Do you think it's the museum? Because usually it's not.
Well, that's what I don't know.
And that's the first question you need to ask. Okay. Like we said in the session, you have to identify what is it that you're using that is copyrightable at all. Now, if it's a statue that was created 1 million years ago, not a big problem, okay? Because copyright expires too. And it's probably not subject to copyright protection at all, in which case you don't have an issue. But if you're talking about a work that could potentially still be subject to copyright protection, then your next question has to be, who owns the copyright? And I doubt it's the museum. Sometimes there is that assignment, and it could be the museum. Not often. The copyright remains with the creator of the work, and it also gets passed down to the heirs when the copyright owner passes away, if the term hasn't yet expired. Now, you might have a contract problem with the museum. That's a different issue. The museum could impose, by contract, restrictions on what you can do in their museum. And they can absolutely say contractually, you can't take pictures in our museum. If you come in, you agree not to. That has nothing to do with copyright. That's a contract with the museum. I would not expect a problem under copyright law for an old building. New buildings, you might have an issue. Old buildings, no. But again, you can't just be thinking in the copyright box, because there are other legal principles that might come into play, for example, trademark law, because buildings, regardless of their age, could potentially function as a trademark for something. An example is the Rock and Roll Hall of Fame functions as a trademark for that organization. Has nothing to do with the copyright on the building, but has everything to do with it being their trademark. So that's a consideration. But from copyright perspective, if it's an old building, as we said, buildings themselves weren't even copyrightable until 1990, but sculptural work is. So you have to decide, is this a building we're looking at, or is it a building that some sculptor affixed their copyrightable sculpture to? And that actually came up in Batman Forever, the movie Batman Forever, in which a court in California actually said, all right, because sculptor said, that's my sculpture, it's fine, you could use that building, but you couldn't use my sculpture. Well, the court said, you know what, there's an exception for buildings. If you chose to have your sculpture as part of the building, you're subject to that too, because there's no way to enforce. Say, well, you can take a picture of that building, but like crop out the sculpture part, that's unenforced. You can't do it. So if you're a sculptor and you choose to have your sculpture as part of a physical building, you get a little exception carved out of your rights there. The book is called Art Law Conversations. But seriously, that's why I wrote it, for that very reason, because people ask me the same basic questions over and over. And there aren't too many resources like that. They can buy my book, certainly on Amazon or on my website, which is rulypress.com. It's RULY press.com. And I didn't intend it to be used as a textbook, but it actually is being used as a textbook in a lot of art schools that have business classes, because it's written for people that really, frankly, just don't have a high tolerance for legal crap. And, it's short, understandable, but does provide that foundation. Well, my rule of thumb would be, just very practically, I would say you need an attorney when there's more at stake than you can afford to lose. Yeah, I do. Don't do it the way I did. I really believe there's a difference between entertainment law and arts law. And the difference has a lot to do with geography. I'm sitting here close to Chicago, where there actually is entertainment law, but I work in Madison, Wisconsin, and that's not a giant, bed of hot entertainment industry. But there is nothing but creative people in Madison, Wisconsin, all of whom have great legal needs, most of which are ignored by large law firms because it's simply not lucrative on those smaller scales. So I call that more arts, because it's the startups and the independents. And for somebody who wants to practice in that area, fine, learn about copyright, trademark contracts, be an artist yourself, understand who you're dealing with, and you can have a practice like mine. I wouldn't call myself an entertainment lawyer, because that really, to me, implies, saltwater or, big industry. And that's just a completely different practice. If that's what you want to do, I think you have to go to New York or LA and work in a big law firm. The manager's job is to advise on artistic issues, and also to advise, on running the business. But I don't do. I mean, I don't do that. I think you have to have a huge amount of trust in the manager, and I have to say, I haven't met. Most of my clients have had bad experiences with managers. I would love to meet more managers that are appropriate fits for artists that I deal with, and I frankly just haven't, because I don't know why. But I would keep them separate. To answer your question, they absolutely need to be separate, and if for no other reason that the attorney has to negotiate your contract with the manager, and the attorney's gonna hopefully be one who's gonna protect you from possibly an unethical manager. Gee, that's an easy question.
Yeah, do you feel positive
That the law will catch up? No. No, I do not. No. The law is hopelessly behind technology, to the extent that much of our copyright law makes no sense whatsoever. The intent of copyright law from the founding fathers at the time of the Constitution was to give a limited time monopoly on your work, not just for the sake of doing that, but so that, because it was a limited time, it would then pass and we'd have a rich public domain. And that's being totally obfuscated by corporate content holders now. I mean, our public domain is diminishing rather than expanding, and in this age, it should be exactly the opposite.
Are you positive about the future of the music industry, just in general?
Yes.
And would you advise anyone who's interested at any level, whether it be business or as a performance artist or whatever, would you advise them, if they're interested, to pursue?
Absolutely. Absolutely. Whether it's music or art or anything else, I think anyone at this stage needs to pursue what they're passionate about and what's going to give them meaning. And they may not end up doing what they set out to do. Most of us don't. But you never end up without taking the first step, and you never know where that path is going to lead.
Well, thank you. It's been great content. Yeah, I really appreciate it.
Sure.